I have been explaining to you the various ways under which a contract is discharged. The best way of discharge of contract is by performance. So, let us recapitulate what are the various ways under which a contract is discharged. Discharge by performance, discharge by mutual consent. Under that particular category, a contract by mutual consent may be discharged by novation, by rescission, remission, by material alteration, by merger, by assignment. So, these are the various ways under which a contract may be discharged by mutual consent. Then I explained to you the various ways under which a contract is discharged on account of impossibility of performance. As regards impossibility of performance, there are two types of impossibilities. Preconditioned impossibilities and supervening impossibility. What do you mean by preconditioned impossibility? Preconditioned impossibility signifies the very performance itself cannot be done. Performance itself cannot take place because the very requisite features, requirements for the performance of the contract itself is absent, whether it is known to the party or unknown to the party. So the very performance itself becomes impossible because of the necessary features that are the requirement for the performance are not there. For example, destruction of the subject matter. When the subject matter itself has ceased to exist and both the parties are thinking that the goods are in existence, Kuturayar versus Hastai, Narsingadas Kotari versus Chatulal. In the earlier case, both the parties entered into an agreement with regard to a subject matter to be exported, which was not at all in existence even at the time of their entering into an agreement. Well, that is what is known as preconditioned impossibility. How can they actually perform the contract pertaining to a consignment which is not at all in existence? The other one is Narsingadas Kotari versus Chatulal, where a land has been agreed to be sold by a seller to a buyer. But what happened? Even before the agreement for sale is executed, the land has been acquired by the government under the Land Acquisition Act. So, these are all preconditioned impossibilities. Then I told you about supervening impossibilities. That is what is known as the impossibility that is other than that of preconditioned nature. That is, the preconditioned impossibility is even before the agreement is entered into between the promisor and the promisee, the goods or subject matter have ceased to exist. The subject matter have become destroyed. But whereas in the other one, supervening impossibility, it signifies a case where agreement has been entered into between the parties or among the parties. But subsequent to the date on which the agreement has actually been entered into between the parties, the subject matter has become destroyed or the performance has become impossible due to various reasons or due to passing of a statute by the government. So these are all some of the things due to which the contract cannot be performed. So this is what is known as supervening impossibility. In that connection, we have been discussing at length about the supervening impossibility, that is a contract which are discharged on account of impossibility. Now, in that particular category, I told you about two important classes you remember. That is with regard to vis majeure and force majeure classes. Majeure clauses, whether they are incorporated in the agreement or not, but they are automatically, they will apply. For example, act of God. Second is destruction of the subject matter. Third is declaration of war. So these are all the circumstances passing of a subsequent statute. Bailey versus Dickrus Pigney, there is a particular case which will actually clarify you as to how the passing of statutes also will make the contract to be performed properly, or they will also be responsible for non-performance of a particular contract. Bailey versus Dickrus Pigney is a case where A sold a vacant plot to B. In fact, under the agreement, it was actually provided by a separate condition that there was a vacant space, vacant land between A's house and the land which A has sold to B. So, the condition that was imposed under the agreement, incorporated under the agreement, was that sufficient space must be left in between the house on which the A's building was constructed, and they should leave sufficient space to an extent of 25 feet so that there will be a gap, and then only B should actually construct the superstructure. That was the condition. But it so happened that the railways, due to development of railway facilities and amenities for providing amenities to the public, the railways under Land Acquisition Act, they compulsorily acquired this vacant space, the vacant piece of plot that was lying between A's house and B's house. And A, under the agreement, has already imposed a condition, incorporated a condition that B should not actually sell the vacant piece of land to any person. But it so happened that on account of the Land Acquisition Act, the railways in fact had acquired that vacant piece of land and started constructing the railway lines. Thereupon, when A filed a suit against B as to how he has allowed the railway department to acquire this land, then the purchaser, B actually pleaded that it is due to passing of the statute by the government, the land had been compulsorily acquired. That plea was accepted by the court, and that is a case where a contract becomes discharged by passing of subsequent statute or enactment. Well, these are some of the various instances under which vis majeure clause will apply. Then I was discussing about force majeure clause. What is a force majeure clause? That is a ground on which the performers, namely the people who have entered into an agreement to fulfill their obligations, they are not able to fulfill on account of their own negligence, on account of their own carelessness. You can say it like that. So, if that is the reason, the law will not excuse, the law will not actually permit them to non-perform their respective obligations to the promisee. So, that is what is known as non-excusable impossibilities. Excusable impossibilities, whether it has been provided under the agreement or not, automatically the court will excuse the impossibility with regard to performance of the contract. But as regards non-excusable impossibility, the court will not excuse any parties who has actually failed to fulfill his respective obligations. That is why it is known as non-excusable reasons. Excusable reasons, non-excusable reasons. Now, what are those reasons which are considered to be non-excusable? These non-excusable reasons are, number one, difficulty of performance. Number two, commercial impossibility. Number three, third party's default. Third party's default with regard to fulfillment of contract. Number four, strike and lockout. Number five, I am going to explain only that. If a contract under its very condition, the very contract which focuses its performance based on several objective features. So, supposing a contract has got to be performed which aims at several objects, not only one object, several objects depending on each other. So, if the fulfillment of a contract completely depends upon the performances of several objectives, and if one of the objectives actually fails, that does not mean that the performance of that contract has become impossible. In other words, where the contract aims at several objective aspects, if one of the objective event has failed, that does not mean that the performance of the contract has become impossible. That is a case of Hornby Boat Company versus Hutton. Hornby Ferry Company versus Hutton. In that particular case, the owner of the boat entered into an agreement with a particular individual who wanted to view the coronation function of Edward the Seventh. So there was a naval fleet that was arranged, and a naval parade was also organized for this king to view. So the king, there was a program for the king to view the naval parade on a particular day. It so happened that Edward the Seventh, on that particular day which was fixed for naval parade, had become sick, on account of which the entire program was cancelled. Now, the person who has entered into a contract with the ferry boat, he said that he has got to be taken round the fleet. No doubt, the parade in which the king has got to take salute, that was cancelled. That does not mean the very arrangement of ships, one after the other, that has been organized by the naval department, that can be viewed at least. So the individual insisted upon the boat owner that he should take him round the boat to see the fleet as to how they have been arranged, how the ships have actually been ornamented. So this was considered to be essential feature, though the main objective might have been cancelled, but that does not mean that the other aspects, that other cumulative events should also be considered as having become impossible. So they have not become impossible. So he could have as well taken the particular individual around the fleet in which ships have been actually anchored side by side, one after the other. Therefore, the performance of a contract which is considered to be based on several objectives, the failure of one of the objectives does not mean that the entire contract has miserably failed from being performed. So that aspect of it you should remember. Then we have to explain what is meant by supervening impossibility. It's a very interesting topic. So far as England is concerned, particularly the English law, they talk more about doctrine of frustration. Frustration means prevention of a particular performance of an event due to reasons beyond the control of human being. So that is what is known as supervening impossibility. The best case you can remember with regard to supervening impossibility is Taylor versus Caldwell. You remember the facts of the case. In that particular case, a music performance was arranged by a particular person who engaged a hall for the performance of this music. So these were the people who used to conduct concerts for people who are interested in music and who are the lovers of music. So it so happened that a music performance was arranged in a particular hall by these persons who were carrying on the club activities. It so happened that that particular hall in which the music performance was arranged was caught by fire, and the entire building got devastated by fire. Then the question arose as to how the music performance has to be conducted, how the music performance should take place. So, the party who has entered into an agreement for rendition of music, he said you should provide for alternate hall. The hall owner was insisted upon by the organizers who arranged for performance of music that the owner of that hall should provide an alternate accommodation for the music to be performed. But he said he will not be in a position, at such a short span of time, he will not be in a position to arrange for alternate accommodation. Thereupon, a suit was filed by the organizers against the owner of that music hall. Then the court said the contract has become impossible, the contract has become completely impossible on account of destruction, on account of the destruction of the hall. So the very hall has actually been devastated by fire. How can you provide a hall, and that too at a short span of time? So this was a typical case of supervening impossibilities. Section 56 of the Contract Act at length gives about supervening impossibility. Now only thing is that you should remember is a contract becomes impossible on account of certain circumstances even before the agreement has been entered into. That is what is known as preconditioned impossibility. Supervening impossibility is a case where the contract becomes impossible subsequent to the agreement that has been entered into between the parties. These are the two things. An event that becomes impossible even before the agreement is entered into. That is the first case, preconditioned impossibility, whether it is known to the parties or not. Section 36 speaks about it. So far as Section 56 is concerned, after the agreement has been entered into between the parties, the performance of the contract becomes impossible due to reasons beyond the control of human being. That is the reason. Now, so far as English law is concerned, they call it, the supervening impossibility is termed by the Englishman as doctrine of frustration. Frustration means that which prevents the occurrence of a particular obligation or a particular event. So, or a particular act. So, that is what is known as frustrated. A contract is actually, they invoke the doctrine of frustration and say the performance has become frustrated on account of the event that has been cancelled. In this particular case, I want you to remember two important English cases. That is what is known as Krell versus Henry and Chandler versus Webster. Krell versus Henry is a leading case. Here also, a person entered into a contract with the owner of a building to view the coronation function of Edward the Seventh, to witness the coronation function, the glory and the pomp and splendor with which the coronation function is carried out is it will be a panoramic scene. So he entered into a contract with the building owner to view the coronation function from a room that was located in that building, which is considered according to the viewer to be an ideal place. So he advanced a token sum of money as earnest deposit, and the balance he agreed on the day on which the coronation function is to take place. It so happened the advance money was received by the building owner, and on the date on which the coronation function has to happen, it miserably failed because the event was cancelled on account of King Edward VII illness. So the coronation function could not be held. Now thereupon, the party who has hired that room, he wanted the refund of the advance money which he has deposited as an earnest deposit to be refunded by the building owner. The building owner filed a suit that the party who has entered into an agreement with him for taking this room on hire, he should actually pay the balance. Now, both the parties contended before the court that the cancellation of the particular event, which hinges on the performance of the act, has become impossible, not due to their own default. Neither there is default on the part of the building owner, nor there is default on the part of the person who wanted to hire this room for viewing the coronation function of King Edward. But due to King Edward's illness, it was cancelled. Then the English court invoked the doctrine of frustration and said both the parties should maintain their status quo. The person who has advanced the money towards rent for viewing the coronation function, he cannot get back the money. And the person who is the building owner, he cannot also file a suit from the person who has taken the room on hire, the balance of money. So the contract has become frustrated. So this is what is known as doctrine of frustration. So far as India is concerned, we are actually referring to section 56 of the Indian Contract Act, which speaks about supervening impossibility. Now, so far as section 56 is concerned, where the parties to the contract have entered into an agreement depending upon the occurrence of a particular event, which is the base for the very performance of the contract. If that particular event becomes impossible, then the contract is considered to be invalid on account of supervening impossibility. Now, in this connection, let me cite an important case, refer an important case, namely Satyabrata Ghosh versus Magneton. That is the leading case decided by the Supreme Court. In that particular case, there was a building promoter. He actually acquired some vacant sites and advertised for selling the plots to the interested person who desired to construct building on that particular vacant spot. So under the agreement, it was actually advertised that earnest money should be advanced. A stipulated earnest money should be advanced. And then the balance portion of the money should be advanced at the time of registration of the plot which the particular party has purchased. It so happened, lot of people came forward, the interested people to buy these vacant sites. They came forward and advanced their money, earnest money. And this was also taken note of, and the promoter actually received the earnest deposits from several prospective purchases. But meanwhile, what happened? The government actually temporarily took over the particular vacant site on which the proposed building was to be constructed by these various purchasers. That particular land, which had been the subject matter of sale by the promoter to the prospective purchasers, that land was acquired by the government temporarily for using that particular land as a godown. They constructed temporary sheds, and the military ammunitions and military equipments were stored for a particular stipulated period of months. So thereupon, then the question arose whether the plots are saleable, whether these plots on which earnest deposits have been advanced by the various prospective purchasers, could it be acquired? Now here in this case, the Supreme Court said that time is not considered to be the essence of the contract. The government who have acquired that land is not permanent acquisition. It is only temporarily they want to make use of the vacant site as a godown for storing ammunitions and military equipments. Therefore, they said the event has become impossible. The event has not become impossible. The event has not become impossible, but it has not been practicable. Immediately, to expedite the matter of registering the sale deeds for the various prospective purchasers, it has not become practicable because on account of the acquisition of this land temporarily as a go-down for the government, especially Defense Department. So, here the Supreme Court said the contract has become void, not permanently, for temporarily for a span of period, till the government actually relaxed the rule and they vacated the premises. Till then the contract could not be performed on account of the reasons beyond the control of the prospective seller and purchaser. So, this is a typical case of supervening impossibility. On the other hand, under section 56, you find subclass 3. In the case of supervening impossibility, sometimes if the person who is a party to the agreement purposely and deliberately prevents the other party from fulfilling his obligation, well, that is a case where the party who has prevented the performance to take place, he should compensate the promisee towards the loss he has sustained. So that is section 56, which you should bear in mind. Now let us come to Krell versus Henry. That is a case where the amount has got to be paid towards rent on the date on which the coronation function is to take place. So there the English court invoked the doctrine of frustration. The other case is Chandler versus Webster. That is a case where the person who wanted to take the room on rent, though he has also paid advance deposit, earnest money was paid by him also. But in this case, quite different from the earlier one, in this case, the person who has taken the room, proposed to take the room on rent, he promised to advance the money 2 days prior to the date on which coronation function to take place. You follow now. You see, the earlier cases, the balance money towards the rent of the room was promised to be paid by the person who has taken it on hire on the very date on which the coronation is to take place. But in the latter case, here the person who has taken the room on hire, he promised to pay the balance money 2 days prior to the date on which the coronation is said to take place. Now, in the latter case, the court allowed the person to collect the money, namely the building owner has got a right to collect the balance money from the person who has agreed to take the room on hire because he has promised. Because the hirer has actually, the person who has proposed to take it on hire, he has already promised the building owner that he will be able to advance the balance money 2 days prior to the date on which the coronation function is to take place. So, this is a case where mutually independent, it is not dependent. But this rigor, this was considered to be very improper and against reason. That is why this was subsequently called as the rigor of doctrine of frustration. The English court said this is considered to be a very strict rule which is insisting for an occurrence of an impossibility. How can a person be deprived of the benefit for which he has actually entered into a contract? So this is considered to be the rigor of the rule of frustration. So the doctrine of impossibility has become a very strict rule and this has got to be mitigated. It is precisely for this reason, subsequently in another case, Parylene versus Jane, there the court actually attenuated or rather reduced the rigor of the doctrine of frustration. The facts of the case have been succinctly summarized in Parylene versus Jane as follows. In that particular case, a person actually took a particular building on rent and he was actually residing in that particular place. And it was agreed to the party, namely the person lessee, the person who has taken tenant, he has actually taken the building for a period of 1 year, 12 months. Just for example, it so happened that war was declared in the meanwhile. The tenant, in fact, agreed to reside in that particular building for 12 months and he has agreed to pay the whole rent for the entire year. He has agreed to pay. Advance some amount of token money and then balance also he has agreed to advance. It so happened on the 3rd month war was declared and the landlord forcibly evacuated the tenant from that premises because evacuation proceedings were taking place in that particular locality on account of declaration of war. So this particular tenant was also affected and he was asked to vacate the premises. Then the building owner, namely the landlord, he insisted that the entire rent for the whole year should be paid to him because the agreement itself has specifically stipulated that condition, namely that the tenant has got to pay the rent for the entire year, whatever thing that may happen. So that was the clause on which the landlord actually was dwelling and insisted. Then the tenant contended before the court, the landlord is insisting for an impossibility. How can you expect the tenant to pay rent for such of those days on which the building was evacuated? Subsequently, the tenant came and actually resided in that particular place in the 9th month. So, from 3rd month onwards till 9th month, the building was actually remaining vacant. Then it was contended by the tenant, how can the landlord insist for payment of rent for such of those days on which the building remained vacant? This was considered to be an impossible thing that is expected from the tenant. Then the rigor is much. He said the law is very strict. Then the court also, after analyzing the facts, came to the conclusion that this need not be fulfilled. This is a doctrine of frustration, and such of those days on which the building remained vacant, the tenant need not pay. That is how the court held. That is what is known as the rigor of the doctrine of frustration was attenuated, was reduced by the court in Parylene versus Jain. But so far as Indian law is concerned, we are completely governed by supervening impossibility. Sir, what is the difference between supervening impossibility and doctrine of frustration? Doctrine of frustration, the plea is raised by the parties to the litigation, parties to the contract. They raise the plea of frustration. If one party is not in a position to fulfill his obligation, he can defend himself by invoking the doctrine of frustration. So far as Indian law is concerned, the parties cannot automatically raise the plea to defend themselves by invoking the doctrine of supervening impossibility, section 56. The court has got to analyze facts and come to the conclusion that the performance of the contract could not actually take place on account of supervening impossibility. That's the first difference. Then the second difference is supervening impossibility. In such of those cases, whatever benefit has been derived by the promisee has got to be refunded to the promisor. As in the case of Caldwell versus Henry, if the coronation function has been cancelled, then the money which he has received as earnest deposit, he has got to refund. If section 56 has got to be applied, namely 56 supervening impossibility. So under Indian law, in the case of supervening impossibility, touching section 65 of the Indian Contract Act, any money that has been derived and subsequently if the contract becomes incapable or impossible of performance, whatever benefit that has been received by the promisee or obtained from the promisee must be repaid to the promisor. So that is what is known as the case of refund in the case of supervening impossibility. So if you know this much the difference between doctrine of frustration and supervening impossibility, that is more than enough. So with this we conclude the discharge of contract on account of impossibility. The next segment is discharge of contract by breach.